Good afternoon, everyone, and welcome to today's webinar, Minor Consent, Confidentiality, and Reporting Child Abuse for Title X Providers. My name is Diana Flores, and I'm one of the Title X Program Managers. Nevada Primary Care Association is a nonprofit organization dedicated to improving access to high-quality, community-based, affordable primary care in Nevada. We provide training and technical assistance to health centers and community partners to improve access to health care for all, especially for underserved and vulnerable populations. For more information, visit us at nvpca.org. This training is a partnership between Nevada Primary Care Association and the National Center for Youth Law. I just wanted to take a moment to thank them for helping us coordinate this session. Before we get started, I would like to go over a few items so that you know how to participate in today's event. During the presentation, please make sure to mute your phone or computer so that we don't have any feedback or background noise. Also, please be sure not to put your phone on hold, or we will be able to hear your hold music. You will have the opportunity to submit your question to today's presenter by typing your questions into the chat panel. You may send in your questions at any time during the presentation. Questions will be collected and addressed during the Q&A session at the end of today's presentation. Today's session will be recorded and the slides will be available to all participants at the end of the session. I would like to introduce today's speaker, Rebecca Gudeman. She's a senior attorney specializing in adolescent health care. She directs the National Center Youth Walk Adolescent Reproductive Health Project and oversees the project's website, www.teenhealthlaw.org. Welcome, Rebecca.
Hi, thank you, Diana. It's nice to be with you today. I will first say that no, I do not look like the photo you just saw on the previous page. My hair was blue for about a month of my life, and we happened to get our professional photos done right then. Now I just look like a regular old person with a lot of white hair, but I guess a lot of us have hair that looks a little different these days in a sort of unique time in our society. As Diana said, my name is Rebecca Gudeman, and I'm an attorney and policy advocate at the National Center for Youth Law. While we do work on improving access to healthcare for young people, we also work in a lot of different areas, including issues related to child welfare, related to young people who are vulnerable to exploitation, juvenile justice, education. So I encourage you to take a look at our website, youthlaw.org, if you want to know a little bit more about the broad range of work we do. But today we are going to be talking about some laws. And of course, because I am a lawyer, I do have to say that this presentation represents legal information and not advice. And the information I'm providing was, oh, I am sorry, I don't know why it says California. It should say Nevada. That's what happens when you are working from home and splitting between watching your kids and taking care of everything else. But it does represent the state of the laws of February 2020. And I don't know about the rest of you, but I've been watching a lot more reruns these days. So I decided to throw up a slide from a photo from one of the shows I've been watching a little bit more of these days, The Good Wife, and some of my fellow lawyers. So just to set the stage before we jump into law, providing health care to adolescents, it's important to remember why consent law and confidentiality law and creating a space for young people to access care on their own is so important. In adolescence, part of development, we're going through some tremendous physical, cognitive, emotional, and sexual changes. And it is a part of that development for teens to want to strive for autonomy and independence and agency. And a part of developing that autonomy is starting to develop more sort of bright lines around privacy. And that's why confidentiality really becomes the cornerstone of alliance between healthcare providers and their patients, their teen patients. It doesn't mean that we're shutting out others in their life, but going back to that word agency, we really want to let young people start to learn to own responsibility for their healthcare and participate in decision making. And that most young people will want to involve a parent or a trusted adult in important healthcare decisions, but it's about being able to bring them into that conversation and have some decision making in that. And that is why in every single state and in federal law, you will find laws that help create a path to healthcare that for a young person to access on their own. So today what we're going to do is cover consent law in Nevada, confidentiality, child abuse reporting, and then do a little context setting because we're obviously in a very unique period where the way that we're delivering healthcare, the questions and concerns we're hearing is different. So I just want to let you know we are holding space to talk about what this means right now, but we're going to go ahead and set the stage by talking about the state of the law first. So it may feel weird to be talking in the abstract about some of these laws when we're in this such unique period, but we will create space to talk about that and then open up for some broader Q&A and discussion if folks have concerns or questions they want to share. So let's dive in. I will note that in addition to being able to get a copy of the slide deck we're using today, we also did create a document called Minor Consent Confidentiality and Reporting Child Abuse, which is available from and was published thanks to our hosts today. So you can find much more detailed information in this document, which is still available. All right, so consent. Who consents to care? Our general rule for a minor is that a minor needs an adult caregiver to consent to health care for them, and the age of majority in Nevada is 18. In general, the person who would consent is their parent or legal guardian, but there are laws that allow others to consent to health care in certain circumstances. If someone's in a temporary guardianship position, for example, in foster care or juvenile justice, we don't have time today to go through all of those, but we did want to flag and acknowledge that there is space in the law for other adults to be able to consent to health care for minor children. There also are laws that allow minors to consent to their own health care. And typically we divide those into laws that allow minors to consent to their own health care based on their status in life, their situation they're living in, and then laws that allow minors to consent based on the type of healthcare service they're seeking, because we have decided this particular healthcare is so important or there are so many barriers to seeking it that we need to create this exception for that type of service. So let's look at first Nevada's status laws. So in Nevada, minors may consent to have their own health care, as would an adult, if the minor understands and requests the care and is either married or has been married, is a mother or has borne a child, has been emancipated by a court, is in danger of a serious health hazard if healthcare services are not provided, or is living apart from their parents and has done so for at least 4 months. We'll talk about these a little bit more when we get into some cases in a second. Sometimes folks ask, well, how do I know if someone meets these criteria? The law doesn't require you to get a signature or have them fill out a particular form. So it's really up to you, your agency, and your risk management and legal department to decide sort of what's the best way for you to capture this information. I know in some places folks create their own form and they have a young person sign it. You don't need to bring in your marriage certificate though, for example. That's not required. Sometimes you might have a young person come in and say that they've been emancipated. In this case, they have to have been emancipated by a court in order to qualify to consent for their own health care as would an adult. So that's the kind of thing, if you do see a lot of independent young people in your practice, to work with your clinic administration on some strategies to be able to easily sort of document and capture who might fall into one of these categories and be able to consent to care for themselves. In addition to these exceptions, we also have exceptions that allow minors to consent to their own care based on the type of service that they're seeking. All services funded through Title X are services that minors can consent to on their own. In addition, under state law, minors may consent to abortion, to sexual examination and treatment for sexually transmitted disease, and to care for and treatment of drugs or related illness. Let's talk a little bit more about the Title X regulation. This is a federal regulation, and it says that federal law says that all services funded through Title X must be made available to adolescents regardless of age without the need for parental consent. And that means even if state law otherwise would require parental consent for that particular type of service, if Title X money is being used to pay for that care, then the minor must be allowed to consent on their own. And there's been a number of different cases in which this was clarified, and the courts have held that this does supersede any state law to the contrary. So let's just look at how this works in action. Angela goes into her Title X provider's office with her mother, and Angela's mother says, "We just found out that Angela's been having sex with her boyfriend. We need to get Angela some birth control and get her an STD test." Angela doesn't say a word. If this were your Title X office and knowing Title X consent laws, may Angela's mom consent to these services for her daughter? So we're going to pull up a poll for you, and we want you to let us know, do you think mom and only mom may consent? Is it mom or Angela may consent, or only Angela may consent? So we'll give you a couple seconds to check off what you think the right answer is here, and then we'll see where we are, and we'll talk about the result. Okay, so 80% said only Angela may consent, 20% said mom or Angela may consent. So the answer in this case is that only Angela may consent. The way the Title X regulations work is it not only allows the minor to consent, it actually requires minor consent. Other folks cannot authorize Title X services on behalf of a minor. Mom can certainly be there and provide support and encouragement, but you need to know that this is in fact what Angela wants, even if that is different than what state law says. All right, so the next case is Elena. She's 16. She comes to your health center, says she thinks she may be pregnant. After some discussions, the nurse practitioner wants to do a pregnancy test, STD testing, and prescribe some birth control. What services may Elena consent to on her own? So again, we're going to give you a poll, and your options are pregnancy, STI test, contraceptives, all of the above, or you don't have enough information. Okay, so folks said all of the above. So let's just talk about the laws related to each of these. So if this is a Title X health center, Title X funded health center, then any of the services that are provided through Title X programming, Elena would be able to consent to on her own. So if this were a Title X center, she certainly would be able to consent to contraceptives, STI, pregnancy testing. If this is not a Title X center, then we need to see what Nevada state law says. Under Nevada state law, if she falls into one of our status exceptions, let's say she's living apart from her family and has been for more than 4 months, she may be able to qualify to consent to general health care, including all of these on her own behalf. If she's a mother who has born a child, she would as well. Any of those status exceptions, she might be able to. if she doesn't meet one of those status exceptions, she would only be able to consent to the services that Nevada allows minors to consent to, which includes STI testing, but would not necessarily include pregnancy testing and contraceptives. Okay, so we'll circle back to consent at the end, but we're going to shift to talking about confidentiality now. When we talk about confidentiality, often folks use the shorthand HIPAA and say we're talking about HIPAA. But in reality, what HIPAA does is it's a federal law that sets a ground floor for confidentiality that is consistent across all of our states. But what HIPAA says is, to the extent that you have any state laws that are more confidential, those state laws would apply instead of HIPAA. So often, what we are applying when we talk about confidentiality is a combination of HIPAA and some state law. In addition, there may be some very specific laws that apply because of the type of funding that you're receiving or the type of service you're providing. And an example of that is Title X. Title X does have its own confidentiality rules. And so if you are providing Title X funded healthcare, then those Title X funded services are subject to Title X confidentiality rules, and that would supersede any state law or HIPAA. So let's look at what the Title X confidentiality regulations say. As a general rule, Title X says that any personal identifiable information about a patient must be kept confidential, and it can only be released if either the clinic has written authorization from the minor patient, or the release is necessary to provide services to the patient, which may be, for example, part of documenting for administrative billing purposes, or state or federal law requires that release of information. And so let's talk about what that last prong means. What does that mean when it says state or federal law requires the release? Examples of such state or federal laws are mandated child abuse reporting, required reporting for certain communicable diseases, or required reporting of certain violent acts. So mandated child abuse reporting, for example, says that if your reporting duty has been triggered, you must make a report. It doesn't give you discretion to decide whether or not to report. That's considered a law that requires disclosure, and thus you would follow your required disclosure law, even though it is otherwise sharing information that is protected by Title X confidentiality rules. So let's look at what Title X says about parent access. Now, Title X, first and foremost, does require that grantees encourage family participation in Title X projects to the extent practical. However, the actual Title X confidentiality rules are very clear that healthcare providers cannot disclose any Title X service information to the parent of a patient without getting that patient's written consent, even if that patient is a minor. So let's see what happens in a case like this. And this is a real case. Someone called me up when this was happening in their clinic. Woman storms up to the front desk of the Title X clinic and says she found some paperwork in her daughter's drawer. She wants to know whether her daughter has ever been to the clinic, and if so, for what services. She has a phone in her hand and says she's going to have her lawyer shut the clinic down if they don't tell her what she wants to know as soon as possible. What may the clinic tell mom? Well, if this is a Title X clinic, even if mom's daughter was a patient here, the clinic is not allowed to disclose any information, and indeed shouldn't disclose whether or not the daughter is a patient. This is one of these situations where the law is actually quite clear and pretty easy to apply. What becomes very challenging, of course, is application. How do you handle that situation and diffuse it, and hopefully find a way to help mom understand why it is that you may not be able to even acknowledge whether her daughter is a patient or not. I'm actually hoping when we get to the end and to the discussion, if any of you have some good strategies that you've used or had experiences with cases like this, that you will be willing to share some of that, because In many cases, the law is actually relatively straightforward. It's the application that becomes challenging, and folks can really be helpful sharing their practical tips and how to do this. Now, I mentioned that one of the exceptions to Title X confidentiality is mandated child abuse reporting. So let's just talk a little bit more about what that looks like and what child abuse reporting requirements are in Nevada. Nevada law requires mandated reporters of child abuse to make a report whenever they have reasonable cause to believe abuse has occurred. And as soon as you believe that you do have reasonable cause, you must share any information necessary to make the report to child welfare or to law enforcement. So it doesn't mean that the whole entire confidential health file is open to law enforcement or child welfare. What you must disclose is the information necessary to make a report. So let's just walk through these rules a little bit more. Who is a mandated reporter? I won't read through this. This is just a couple examples, but you can find the full list of folks who are considered mandated reporters in the manual I mentioned up front. Most medical professionals are mandated reporters of child abuse, and in addition, folks who may be administering or managing a clinic and who are notified of abuse are then in turn become mandated reporters of abuse. When must a mandated reporter report? They must report when in their professional or occupational capacity they know or have reasonable cause to believe a child has been abused or neglected. So what I really want to highlight in this is that phrase in the professional or occupational capacity. You may be a mandated reporter when you are in your office or providing healthcare services or other professional services. But let's say it's after work, you go to the grocery store and you see something that you think provides you reason to believe that a young person's been abused or neglected. In that situation, you are allowed to make a child abuse report, but you are not a mandated reporter because you're not seeing that abuse, or the information that's leading you to suspect abuse is not coming to you through that professional or occupational capacity. Now, this is a question that I hear often, so we thought we'd throw it in. Well, what if I hear about abuse that happened a long time ago? I have an adult patient who discloses perhaps that they were sexually abused when they were in elementary school. Am I still required to report? This question actually went to the Nevada Attorney General, and it was in the context of an adult patient disclosing historical abuse in therapy to a psychologist. And what the Attorney General said is that if that psychologist or other mandated reporter learns that an adult client was abused or neglected as a child, the psychologist or other mandated reporter is not required to report such abuse or neglect. Now, that said, if you hear information about historical abuse and you believe that there may be, your particular patient may not be at risk, but there may be other children currently at risk of abuse from that same abuser, that may change the situation, because you could still say when they're disclosing to you that through your professional capacity, you're hearing about children that may be at risk of being abused or neglected. So the question would be, is this a situation where you believe that there may be a child currently at risk? What is reportable? Child abuse or neglect is defined in Nevada law for reporting purposes, and it includes what the law describes as physical or mental injury of a non-accidental nature, sexual abuse or exploitation, or negligent treatment. Each of these is then defined in turn. We did put slides in with descriptions. I'm not going to spend a lot of time on these. I'm going to because I want to have more time to talk about what is considered sexual abuse for child abuse reporting purposes. But you do have a slide here on what is physical injury. It's also in the manual. Reportable mental injury we have defined. We also have negligent treatment defined here, so you can refer back to that later. It also includes sexual exploitation. What state law says is that forcing or allowing or encouraging a child to solicit for or engage in prostitution or view or a pornographic film or literature or engage in filming or modeling for such all is considered sexual exploitation and is reportable. A lot of the language that you find in the law may not be quite as current with sort of the framing and language we use now to describe some of this. Now, what you will hear more commonly is about trafficking, and just taking a step backwards. In terms of federal law, we usually categorize trafficking in 3 categories. Category 1 are adults who are involved in commercial sex via force, fraud, or coercion. Category 2 are minors involved in commercial sex. So that's really everything we just described here under sexual exploitation. That is considered category 2 of trafficking. And then category 3 is actually the sort of forced labor trafficking that we sometimes hear about, involuntary servitude. But category 2 in this chart is reportable as child abuse. What else? What is sexual abuse? Nevada law defines sexual abuse in reference to criminal laws. And so it lists a number of criminal categories: incest, lewdness, sexual assault, statutory sexual seduction. I'm going to go through a couple of these and just pull out some of the areas where there's the most frequent questions. So what is sexual assault for reporting purposes? It's any time a person subjects someone else to sexual penetration or forces them to make sexual penetration on themselves or on a beast against the will of the victim or under conditions in which that person should have known the victim was mentally or physically incapable of resisting or understanding the nature of his or her conduct. So that would arise, most frequently that arises when we're talking about someone who may be under the influence of alcohol or some other intoxicant, and whether they should have known that this person was incapable of understanding the nature of what was going on and incapable of providing consent. In addition, state law defines certain activity as illegal based on the age difference between the 2 parties involved. There's no, it doesn't matter whether there was force or consent. It's age alone that makes this illegal and therefore reportable. And it includes any sexual penetration by a person 18 or older with a person 14 or 15 and at least 4 years younger. Or any sexual penetration with a child under the age of 14, irrespective of the age of the other person. It includes any lewd or lascivious acts, which is sort of touching. It doesn't need to be penetration, but sort of other sexual activity with the age categories defined here. You can read through this on your own. So it does mean that there's quite a lot of categories of sexual penetration, sexual intercourse that must be reported based on age differences between the partners. But the law also makes specific exception and says it is not reportable when similar age minors are engaging in sexual activity and there is no reasonable suspicion that one person subjected or forced the other person to engage in that activity, or that one person was mentally or physically incapable of resisting. These slides are a lot of words. I'm a visual learner, so what I like to do is try to translate that into a sort of a chart, sort of how do we turn this into actionable information. So this chart is a visual representation of a lot of what we just saw. If somebody has engaged in sexual penetration and you have absolutely, and we consider it voluntary, meaning there's no suspicion at all that there was any force or coercion involved, there's no concern at all that there was anything making it someone incapable of resisting or understanding the nature of the conduct. So you have no concerns in that category. You're simply wondering, well, based on age alone, do I need to report this? If the ages are in the purple box, then you would. So for example, age of one partner is 13. Irrespective of the age of the other partner, you're going to make that report because it's in the dark purple box. If one partner is 15 and the other is 17, it's in a green box. That means as long as it truly was voluntary, that's not considered sexual abuse that has to be reported to child welfare. The light purple are highlighted because the law requires a report if there's at least a 4-year age difference, and that is right at that 4-year line. So exactly depending on sort of where they are there, you need to sort of do your calculation, but you may need to report based on age. Okay, so let's try to put some of this in practice. So we're going to do some more polls for you. Lola's 14. She's come to your Title X clinic for a pregnancy test. She discloses that her uncle made me do it with him and thinks she may be pregnant. And in fact, a pregnancy test confirms that she is. Must the clinician make a child abuse report in this case? So we'll get your poll popping up. Let us know, do you think there is a required abuse report here, there's not, or you need more information? Okay, we have 89% saying yes and 11% saying need more information. Totally okay to say need more information, but if we do have it, if it does confirm that we have a reasonable suspicion that this was a case of incest or voluntary sex between someone who was over 18 and someone who was 14, then that would require a report. So for example, if we look in the box of 14, someone's 14, as soon as they're engaging in even voluntary sexual activity with someone 19 or older, that would be reportable, separate and apart from the uncle issue. All right, our next case, this one we're also going to have you do a poll on. 17-year-old Brianna presents at your Title X Health Center requesting emergency contraception and an STI screening. She says she was at a party on Saturday night and got wasted. She had sex with another 17-year-old and is concerned about pregnancy and STI. Is this reportable as child abuse? So your answers are yes, no, or need more information. Okay, so we have 6% yes, 47% no, 47% need more information. So in this case, we would not be required to report based on age alone, because these are two 17-year-olds, but there are certainly some questions in here that may make us wonder whether this was voluntary, and by the definition of voluntary, was Brianna mentally or physically capable of actually resisting or understanding the nature of the conduct? She used the term wasted, and this may well be a situation where you believe you have a reasonable suspicion that she did not voluntarily participate, or you want to ask a few more questions or find out what else happened before to see if this really was something that you could say is voluntary. Okay, so now you decide that a child abuse report is necessary in one of the previous cases. What's the next step? Once you've decided that a report's necessary, you have 24 hours in order to make that report. You can make your report by telephone or by any other means, oral, written, or electronic. And that report can go either to child welfare or law enforcement. Sometimes you'll hear child welfare saying, oh no, we only get X kinds of reports, and law enforcement saying, oh no, we only get Y kinds of reports. But the law says you can report to either agency. There is a whole list of information that you're supposed to include in the reports. you may not have all of this information at hand. If not, you still make your report and just provide the information that you do have available. For example, you may not know if there's any evidence of abuse or neglect of children in the house, or have an address or even a name for the alleged abuser. It may be that someone tells you that they were raped at a party, you don't know the name. It doesn't mean you don't make the report, it just means that you may have to leave that part blank. But if we circle back and think about Title 10 confidentiality law, the important point to remember is that Title 10 does provide an exception and says that any information that is required in order to make a child abuse report can be disclosed, even though it would otherwise be considered confidential and protected. So any of this information here could be shared despite Title 10 confidentiality rules. All right, so let's do another case. Eliana's 15 and she's come to your Title 10 Center for Pregnancy test. The result is positive, and she tells a clinician that her 21-year-old boyfriend and her mother will be really happy with the news. Based on her age and her additional information provided, you decide that you must make a child abuse report. So you're going to make this report. May or must you inform Eliana's parents that this report was made? So we're going to pull up a poll for you again. And the question is, yes, you think you do have to inform her parents that you're making this report, or you're allowed to inform them, or no, you can't inform them, or you need more information in order to decide whether or not you're allowed or required to inform them. See, we've got 20% said yes, 47 said no, 33% said need more information. So this is a Title 10 clinic, and that means in general, the information is protected, and in general, information cannot be disclosed to a parent without getting written authorization from the minor patient. Child abuse reporting is an exception to Title 10 confidentiality law, but what it says is that information can be disclosed to child welfare or law enforcement as part of making that child abuse report. It does not say it can be disclosed to child welfare, law enforcement, or parents. So in this kind of case, if you are making a child abuse report here, you are not allowed to inform mom that you made that child abuse report, even if you want to. You would need to get Eliana's explicit written permission before you shared that information with her parents. Now, it may be something that you talk with her about and sort of like, look, Eliana, law enforcement or child welfare may well be coming out to your house. This might be something that you want to share with your parents, or you might want me to talk with your parents about it, but if you want me to do it, I need your permission. But without that permission, you are not allowed to let mom and dad know that you made that report. Okay, so we started talking about this just a little bit. There is a bit of an art to reporting. Now, this is information that comes from a clinician. This is not from me, a lawyer, but this is some of the advice that you'll find in the manual regarding how to do trauma-informed child abuse reporting. The first recommendation is to always set the stage. So in every interaction that you're having with an adolescent, set the stage up front, talking about both their confidentiality rights and protections in order to also reinsure them and create that sort of cornerstone of confidentiality. But as you're providing that scope of what is confidential, make sure that they understand very clearly what situations might trigger a breach in confidentiality, such as required child abuse reporting. Some providers say, well, if I tell them I have to report, if you tell me you had sex with someone who's XYZ age, then they're not going to tell me. It turns out, according to many years of studies that that's in fact not true, that even after having laid out very explicitly what some of these exceptions are, young people often will disclose. They may not disclose in that first appointment with you, but they might disclose in that follow-up appointment. And that when they do disclose, they're doing so sort of more agency, and it helps preserve that relationship with the clinician, which is so important. When you do decide that a report is necessary, frame that mandate in the context of getting help rather than this is something I have to do. So, oh, we're going to make a report. It's not because, I have to make a report because the law says so. I have to make a report because we are worried about you. We want to make sure you get the help you need. We care about you, sort of that kind of framing. And then always make sure that you keep safety first and foremost in the front of your mind. If this is someone, for example, who may be in a vulnerable trafficking situation, let's talk about their real immediate and practical needs. Arrange for alternative placement if they're not safe at home. If there may be someone out in the waiting room waiting for them, making sure that there is a safe space or that we meet any urgent needs for housing, food, or protection for physical safety. Okay, so I know we sort of skipped through a lot of that quickly. We will make sure we get to questions that I'm sure have popped up throughout, but we also wanted to make sure we made a little bit of space to talk about what some of these rules mean in the context of COVID and shelter in place. And many of us are doing telehealth now and having to bring it online, and when we've never been doing it before. I would be happy to hear about any experiences or questions, concerns you have in that context. What I can tell you is whether we're doing our healthcare by telehealth or by video or on phone or in a parking lot, the consent rules stay the same and the confidentiality rules stay the same. HIPAA does have some very explicit requirements for technology when you're doing telemedicine and documenting. Those were quite challenging, but the federal government has effectively given folks a pass on those and has issued some guidance. I'm sure that clinic management and clinic legal counsel have already taken that into account when they're setting up telemedicine for any of you who may be doing that. The federal government has issued some very explicit guidance on some of the different technology that we're allowed to use to do telemedicine, like Zoom for Health, for example. If you're doing telemedicine and your patient is sitting at home in what might be a shared room, for better or worse, the confidentiality rules we have to apply remain the same, and we have to do our best to find a way to ensure that that young person has a space in which to communicate with you in private and has the ability to control who may or may not be hearing the conversation or seeing what they might be typing online. Sort of how we do that, sort of practical strategies are the kinds of things that we're seeing folks sharing now through different listservs in the medical community. It's really challenging. If anyone on the call today has any suggestions or tools that they've used, please, we welcome you sharing them or encourage you to share with your colleagues. And we also wanted to, at this time, open it up for general questions or sharing about best practices in some of the other categories. So with that, I want to reach back to Brandy and Diana and see if we have, I haven't been monitoring the chats. Do we have any questions coming in?
So there hasn't been any questions in the chat box yet. If you would like to ask a question, you can raise your hand and I can unmute your line so you can ask your question. Okay, it looks like I do have one in the chat box that says, thank you for a helpful and practical presentation. Written minors' consent to share info. How do family planners obtain minors' written consent to share info, patient info via a telemedicine or telephone encounter?
Oh, that is a great question. I'm trying to think. So all I can do is provide legal information, not legal advice. And so I'm trying to think how much I can say or what to say. Um, I I think that may be a question that I need to direct back to your clinic management and legal counsel to answer. I know that I know some different agencies have adopted some different strategies, but I'm loath to share those examples because I don't want to imply that um, is the right answer. I think the truth is that in some cases, folks are doing some risk management here and saying, I'm not sure if this 100% complies with what the law requires, but we're going to do the best we can because we know this is all we can do right now. And so I'm afraid that I'm going to defer answering that one, even though I think it's a really good question and I encourage you to bring it back to your clinic.
I know Dawn mentioned signature secure files emailed or text for patients and parents to sign as applicable. She can talk about this if you'd like her to.
Well, so that's great that that's being shared. I think I feel more comfortable having folks share best practices like that directly.
Okay. And I saw some hands that were up that aren't anymore. Is there anyone else that has a question that I can unmute you?
Well, as folks may be typing or thinking, I just wanted to flag that this is my contact information, and you can always follow up later. We do have that manual, which I believe may go out with the slide deck. I'm not sure, but certainly we can. So if you do think of things after the end of the presentation, or you're seeing a recording of this later, feel free to contact me through either of these two websites.
I do have one that asks if you can speak a little bit about a little to the call center and how to gauge minor consent issues in the call center.
Can you explain more what you mean by call center?
Let me see if I can get her unmuted. One moment. Kristen, can you unmute your phone and talk for a second?
Can you guys hear me?
Yes.
Yes.
Oh, excellent. Okay, so really what I'm curious about is how do we go about, so, when a patient calls and they are a minor and they're calling up to the call center first to make an appointment, how do we kind of go about handling any kind of issues around that piece? That's something that we haven't really thought through all that well yet, I guess. So any help there would be helpful.
So sort of one of the questions is, are they allowed to set up appointments for themselves, for example?
So yeah, I guess that would be a question. And then also, so, when parents also do call, and so I guess the challenge that we could run into is a parent would also call and be like, oh, well, my child doesn't have an appointment. Oh, but your child does have an appointment. And it's something that's confidential versus an appointment that the parent made for them. Like, how do we mitigate that?
Got it. So depending on the way that appointments are set up, I've seen folks do different things. Sometimes they'll, if it is clinics that know that they provide a lot of confidential Title X services, for example, to minors, they may actually just impose blanket policies that say they won't disclose information once patients are between, let's say, 10 and 18 years old, or 12 and 18 years old. And that way, parents hear this message that this is part of our practice for our agency that we have this practice across the board, whether, and it's not about minor consent or not, it's not about what we think of your child and the risk that your child may be engaging in something, and it's not about what we think of you as a parent. This is about our practice to help encourage adolescent development and make sure that we can honor all the rules. And so we're imposing a blanket policy that encourages the young person to sort of speak for themselves. That doesn't always work. It depends on the client population that you have, but putting in place some practices like that. There's a group called the Adolescent Health Working Group that put out a toolkit manual that has some sample letters to parents when your child turns 12, some sample scripts for sort of how to adopt that kind of practice for that initial first step engagement. Then the other side of this is sort of when someone's following up on, let's say, what can be tricky is if a young person is coming in for sort of a well child exam, and then as part of that exam, the young person says that they would like to talk to the provider about some confidential services like contraception or STIs. There needs to be some strategies to make sure that there's ways to segregate that in both in physical paperwork, but also in computers, and flag it so that when there are those phone conversations or communications going out, that whoever is handling the communication understands what is information a parent is allowed to see and should see, and what information shouldn't be communicated. So that doesn't provide a lot of particular concrete examples, but I encourage folks to take a look online, Google the Adolescent Health Working Group Minor Consent Toolkit, and they have some sort of practical tools for how to implement some of that. It sounds like we may be done with questions, but as I said, feel free to contact me if something comes up later. I'm sorry that I can't provide more concrete sort of practical advice, sort of crossing that line, but I have to be so careful about crossing that line, but I encourage you to bring back some of those questions to your own clinic to sort of sort through some of the practical, and like I said, look for that Adolescent Health Working Group Toolkit, and reach out if you want any further information.
All right. Thank you, Rebecca, and thank you everyone for attending today's webinar. If you have any other further questions, you can contact me at dflores@nvpca.org. Once you leave today's webinar, you will receive a survey on the presentation, and we would appreciate it if you complete that survey and provide us feedback. On behalf of the Nevada Primary Care Association, thank you for joining us today, and have a great rest of your day. And we will be sending out the PowerPoint slides and the copy of the minor consent and confidentiality manual that Rebecca Gudeman went over. So thank you, everyone, and have a great day.
Thank you. Bye.